Welcome back. It is my pleasure to introduce our next speaker. Lisa Gonzalez-Goetz is a founding member and partner of the law firm of Gonzalez-Goetz and has been dedicated to Social Security disability law and other areas of disability law. She's going to speak to us today about disability law and chronic disease. She will be available for questions at the end of her presentation. So you can feed those questions into the chat and we'll get to as many as we can before the break. Thank you. And I will let you take it away.
Thank you for having me today. I'm privileged to be able to assist as many people as I can with the complexities of Social Security disability, the application and requirement processes. I'm going to kind of go through the slideshow a little bit quicker than I usually do so that I can get to the Q&A sessions. But in terms of my experience, I graduated from law school in 1992, Temple Law School, and I have been representing the disabled since then, exclusively doing this area of practice. So many people call me an expert. I find that I'm still learning and always have an interesting case. So let's get to it. Basically, the Social Security Disability Program has several different applications that you can do, but the major two are disability insurance benefits, which is also known as Title II, and supplemental security income, which is known as Title 16. They each have different requirements to be able to apply for that. So next. For both programs, you have to show that you are unable to perform your past relevant work or any work in the national economy. And the reason that you're not able to perform it is because of a medical condition that is severe. It can be a mental or physical combination, or a physical or a mental impairment, or a combination of them, which tends to be the case. And finally, that the disability has been severe and is expected to last 1 year at least or result in death. Next. So as you can see, the definition is quite simple. Yes, I have a disability. Yes, it prevents me from working. And yes, it's going to last 1 year or more. But the simple definitions are often what get very complex in interpretation. So the question becomes, what is work? What is a disability? And why is it expected to last more than 1 year? So I find that the most successful attorneys are those that are well prepared. And to be well prepared, you have to really have a lot of communication with your client, know the circumstances surrounding their impairment, the work history that they used to do, and then really granulate their impairment in how that affects their daily living, and how your daily living then affects your ability to get up, go to work, perform work on a sustained basis, which is defined as 40 hours a week consistently. So if you have difficulty getting up in the morning, you have problems with work attendance, or if you get to work and you have problems being able to remain on task or concentrate, that would prevent work. So it's really, really important to get everybody on board, the clients that are applying, the attorneys. You don't need an attorney, but I strongly recommend one, and your medical doctors to assist, so that by the time you get into a hearing, which is where most cases are won, that you have all this information ready to go and your testimony is tight and you're able to really just persuade the judge. So for medical records, It's much easier when we have objective records such as blood tests, MRIs, x-rays, surgeries, anything that's objective. And then we cushion that with your testimony, and that is known as subjective. So we put those two together and in the desire to be able to overcome the burden in front of an administrative law judge and show that we are not able to return to work. Many times the hearings have vocational experts, and they're supposed to be experts that talk about the jobs available in the regional or national economy and what jobs would be available for you to perform with your impairments. So we preempt that with our preparation so that by the time we get to the medical expert, we've already laid the foundation of how your disability interferes with your ability to work and your lifestyle. Okay, next. So you can see preparation is really important. In the beginning of my presentation, I was talking about different kinds of cases for disability. Basically, a person who has worked 20 quarters, which is 5 out of the last 10 years, you will see it in the next screen. It shows you all the income that you've ever received and whether or not you qualify for Title II disability. Then there's also supplemental security income, which supplements your income if you're indigent. Like I said before, for both programs, you have to show that you are unable to work for a period of 12 months or more due to a disability. But for SSI programs, you have to show, in addition, if you've never worked or haven't worked enough quarters to have coverage, you then have to show that not only are you disabled, but that you are also indigent. This is an example of the new system, new for the last 6-7 years, that Social Security has with respect to electronic records. And when you log on, once you've put in all your information and you've opened your case, you can see your file like this. So it's really nice for an attorney because instead of waiting for a physical file or copies of papers, we can see that every single piece of evidence that gets submitted to Social Security is received, exhibited, and it's in real time. So we find that really, really helpful. And hopefully the government will continue to adapt to modernization and making it easier for claimants and attorneys alike to access their file. Okay, next. So these are an example of your earnings record. It's all the wages that are recorded prior to your onset date, which is the date you became disabled or you're alleging disability. And then it shows how much money you have received. In some cases, many people throughout this process will try to return to work, and the jobs and the work and the hours and the money they receive are interrupted because of their condition, and they're not able to do what's called substantial gainful work activity, which is 40 hours on a consistent basis. So if you're not able to work, or if you worked and earned very little, these will show in your earnings record. And then based on this, we're able to say to the judge, for example, if you last worked in this case in 1999, but in the year 2000, you returned to work and you earned $4,460.16, we can argue that that's an unsuccessful work attempt because you actually tried to return to work and were unable to. And those have certain amounts that they consider what substantial gainful work activity is. And many times, anytime you go back to work, it throws a red flag to the government that maybe you're keeping your hours artificially low so that you can double dip and get some money and qualify for disability. Interesting to note, if anybody has ever had long or short-term disability or workers' compensation or a VA claim or a personal injury accident, you have a percentage of disability. They rate you 40%, 90%, 100%. For Social Security purposes, there is nothing under 100%. You have to show that you're able to work or that you're 100% disabled. So it kind of deflects and affects any person who's trying to return to work, or any person that would like to work when they feel good and then not work when they don't feel well. They won't qualify for disability. So whether or not the system will change in DC and laws will adapt to a percentage, it's probably very difficult to monitor. So it's very easy for the government to say, we either consider that you are not disabled or that you are. And if you are, it's 100%. And if you're not, it doesn't matter whether you're 95% or 30%, we're going to deny your claim. Okay, so that's an example of an earnings record. Okay, next. The Social Security Administration is allowing what they refer to as compassionate medical allowances. And the compassionate allowance are for conditions that are irrefutably medical conditions which will affect your disability. And it kind of brings you from the back of the line to the front of the line. And keep in mind that these cases generally can take 2.5, 3 years on average. So some cases take more, 5 years, depending on how many appeals we do. And some cases, such as the cases of compassionate allowance, should be paid pretty fast because your life is at stake. So next is an example of compassionate allowances. Go ahead, next. I think I already said that. These are examples, a list, which fall under compassionate allowances. Again, for a complete list of impairments, you can Google it, but this is an example. And these examples require very stringent objective medical records. So you can't say, oh, I fall into this category, I have cancer, or I have, no, you need to show that it's imminently going to affect you and result in death. I find that very few cases are given on compassionate allowance because any disability doctors turn around or Social Security turns around and says, well, we don't expect it to last a year. So you may be severe right now, but we think after treatment and within 8 or 9 or 10 months, you're going to be fine and be able to return to work. The only fear with compassionate allowances is that when they do grant compassionate allowances, and then if they appeal it, the monies you received as compassionate allowance, if you fail to win your case, you have to pay back to the government. We use compassionate allowance in our firm with very severe cases where the livelihood is not expected by the time their case gets resolved. But this is available to many people with severe chronic illness and proper documentation for it. Okay, next. The application process. You first file an initial application. Some attorneys, I've come to find out, only take cases once you have been denied twice, which is at the initial and the reconsideration. And it's because that process can take 2 years. Right now, for example, many of the disability determination services offices, which are offices that the Social Security Administration uses to develop your case, send you to doctors, review medical records, request medical records on your behalf. It is taking 366, 67, just over a year days, 366 or 67 days, depending on your region, for you to be assigned to a case manager. Once you get assigned, then they start working on your case. So the way the process goes is you file an initial application. You can do it through an attorney. We take cases at the beginning because I just find it easier to kind of monitor the dialogue a little bit and give each client an understanding of what's going to be needed later. So there's an initial, if you get denied, you have 60 days in which to appeal. Then you have a reconsideration process. Then you have a denial, or if you were to have a denial, you end up turning around and having to request a hearing. And that's when you're actually able to go in front of an administrative law judge and testify and give what we call subjective evidence about your impairments and your condition, how you feel, how it affects you. And that's where we get a lot of the cases won. There are times that we don't win at a hearing level, which we then determine whether or not there was an error in the decision writing process, and we appeal it, which is an in writing appeal to the Appeals Council, which is in Virginia. And if that's denied, because we find that many times, unfortunately, that appeal seems to be a rubber stamping of the administrative law judge's decision, then we go into federal court, depending on the circuit and depending on the errors of law. At the initial and reconsideration level, which are the first levels when you apply, there are different listings of disorders, which I've highlighted some of the most common here. And the listings of disorders are very specific. So they say, for example, that you have a positive finding with this, with a problem with this. So you need to really read the listing for an and or definition of exactly what you have. Many times your doctor can assist with that. And if you meet a listing of disability, or if you're a certain age, education, prior work background, you should be an automatic win. But if that were the case, I would be doing another type of law, because that is seldom the case. Or the government, which is what they're doing now, is they're saying, well, we'll find that you met this listing, but we're going to change your onset date. And we don't believe that it's been since 2022 that you've been this severe. We're going to give you the benefits as of 2 months ago, May of 2024. In which case we determine whether or not we're going to appeal that time frame or not, because many times they try to negotiate, and it's really disheartening for people who also need their Medicare, which comes from a fully favorable decision with Title II, or their Medicaid, which comes from a fully favorable decision of Title 16. So that's one of the ways we can bypass the long process. Okay, next. Okay, so that's the nuts and bolts, very simplified type of practice that if it were so simple, it wouldn't have taken me 31 years to be doing. And I really rushed through it. My email is on my contact information. So if you have some questions that require an answer that are more private, or if they don't have time to get to your questions, I will answer the email at this email, lisa@gglaw.info, to at least assess and let you know what the best course of action is for you. Okay, thank you.
Thank you so much for that excellent presentation. I appreciate your sharing your time and expertise with us today. We do have a question in the chat, and if it's outside your scope of practice, feel free to let us know. But you probably have a better sense of it than any of us
Okay.
listening in. This relates to school systems and ADA law, 504 plans, accommodations. What recourse do parents or children or adults have, for that matter, if their school or workplace refuses to provide accommodations? And if the school system, for instance, will not agree to a 504 plan that's necessary for the health of the child? So that's like a lot of questions rolled into one, but
Okay. So I get these questions asked very often, and unfortunately, it is outside my scope. What I will say that parallels these accommodations is that if you want to work and you're able to be accommodated with hours or chairs or equipment or shadowing, then you won't qualify for disability. Because the whole reason that you're applying for disability is because you're alleging you cannot work. With ADA, you're actually saying, I can work, I want to work, I just need accommodations. With the school system, there are students and children that we represent that have a lot of accommodations at school, and that helps us represent them in their Social Security disability case. When it comes to the school not offering accommodations at that time, what I find the best is to find attorneys that work directly with the school board or against the school board, or in the particular state that you're in, find an attorney that does ADA law, because law is very, very specialized these days.
And that makes sense, makes perfect sense. Our next question does relate to disability. And you've talked a good bit about Social Security disability. Many people do have also workplace or individual disability policies. Are there differences in qualifications for those types of plans? And what do people know who are considering applying for disability, either through Social Security, their individual plan, or workplace plan? What do they need to know and do before they start that process? I know if you do it wrong, sometimes it can hurt the process, right?
Okay, that's a great question, and it's a very, very complicated and individualized question. So my answer is going to be very general in nature. And before I give an answer, first remember that Social Security disability is a disability that's available for any U.S. citizen or anybody who's paid money into the system. A short or long-term disability, employer-backed, is a contractual obligation. So every single long or short-term disability that you may have from your employer is going to read differently. So that's why there's no set answer. What I do know is that when you file for short or long-term disability, these are insurance companies that will then have you file for Social Security disability so that they can offset the money. So let's say you're entitled to receive $2,000 in your long-term disability claim a month, $2,000, and you're only entitled to receive $1,200 under your earnings. You're not going to get $3,200 if you win. The insurance company, unless your policy is over 30 or 25 years old, because I do remember seeing these where you could double dip. Now they're too smart. They don't do that. They actually make you file. Every insurance, long or short-term disability, and I'm going to focus on long because with what I do, you have to show 12 months or more of an impairment, and that typically covers the long. You start with short and it moves to long, is that they make you apply for disability. Some insurance companies make you apply and appeal and exhaust all remedies of appeal. and they will have their own in-house attorneys or representatives, not attorneys, representing you as a client, or they'll pass you to an attorney to try to win your Social Security claim. Some long-term disabilities only require you to apply. If you get denied, it doesn't matter. That's all they require because they're trying to offset. So the most important thing when you do any kind of application with regard to disability is to line up all your ducks. Make sure that your doctors are in agreement with you so that when they complete forms, they're complying and assisting you, as opposed to you starting the process on your own and then having the doctor say, oh, I can't fill that form out. So you want to line that up. You want to make sure you have your caretaker's support and your family's support. And I find that that's probably the most important thing when you start going through this process. But one is a contractual obligation between you and the company that you started making payments to. And the other one, which was the one I spoke about, is about Social Security disability. So you can receive both, but with long-term insurance, they will offset. I recently spoke to an attorney that works on ERISA cases. After they win their Social Security disability, they may qualify for back pay of long-term disability. And when he was explaining to me what he did, it was a little complicated. So it really is on a case-by-case basis. And I would welcome anybody who has a specific question to let me know. If I don't know the answer, I will try to find it or at least direct you to the best place. But great question.
Wonderful. And that is a great point, that those LTD policies, either individual, private, or through work, are contracts. And you either meet the terms of that contract or you don't. And definitely wise to read it thoroughly first. I know many organizations will recommend people who do have chronic illness that they sign up for those workplace plans because they may not qualify for individual policies based on pre-existing conditions.
Which is terrible, which is absolutely contrary to public policy. I mean, it doesn't help society in the least, but that's for another time.
It is, yes, many issues there. Another question in the chat, this relates to children. So some children do qualify for disability. Do you have any advice for parents getting benefits for their children? And the questioner is asking for children who do not qualify because one parent makes too much for SSI.
Okay, so you can't overcome the financial requirements from SSI. So like I said in the beginning, you have to be one program or another or a combination. But in the case where you have children, the parental income will determine whether or not you qualify for SSI. Because the thought of it is, if the parents can take care of, why does the government have to take care of? Now, every state has found monthly programs to kind of help overcome that, which is if you show that in Florida, for example, that 90% of your income is already exhausted and you don't have the money to give the child what they need, then the state will kind of come in and give it, but it's not through the federal government. So there are, because the federal government's kind of up here, then there's state, then there's county, then there's city. So there are availabilities for that. When it comes to children's cases, I'm very particular of the cases that I take for children more than anything, because once a person is receiving disability, they'll know for life that you are receiving disability. So if you have a child who's 7 or 8 with behavioral problems and ADHD, and you want to get them disability because you can get some extra money and you need medication and early intervention treatment, that's great. But if they want to 10 years later go to the armed forces, they're not going to qualify because they have this disability marked on them. So I'm very, very particular. But with that said, there are a lot of children that are denied benefits that are entitled to them. The financial aspect, you can't do anything about. I know that in my experience, and I have divorced people just so that the income is not so much, which is, again, contrary to public policy, not something that feels good, but definitely a need that has to be addressed.
All right. Well, thank you so much. We have a comment in the chat that you are amazing, and thank you so much.
Thank you. I appreciate that. Thank you.
We appreciate you sharing your time and expertise. It is a complicated process to navigate, and having some understanding, I think, helps our members. Thank you very much.
Okay, you're very welcome.
We are going to take a brief break and come back with Dr. Bussey.